Good afternoon, everyone. This is Andrew Agris with LA NHRA. We are at 101. We are going to give it a couple minutes for attendees to join, and then we will get going. We'll give it just a couple seconds, and then we'll launch. All right. Looks like the numbers are going up. So again, my name is Andrew Agris. I'm the past president of LA NHRA and the current program chair. I am once again really excited to have Hannah Sweiss and Nicole Kamm with us from Fisher Phillips. I think they're getting tired of saying yes, but every time I ask them, they always do. And then we're really fortunate to have Lorenda Edmundson, who's a senior workers' compensation claims analyst at Bolton Company. And I've worked closely with Lorenda over the years, and she's put on so many of these webinars, she could probably do them in her sleep. So we are broadcasting from my television room because my home office is right next to my daughter's bed, and she's taking a nap right now. So if there's some difficulty on my end, just put it in the chat box, and I'll go to a different room where the Wi-Fi might be a little bit better. You do have the option to ask questions in the chat box. We'd like to try to keep questions in the Q&A box. So if you wouldn't mind asking questions in the Q&A box, we will be tracking those and make sure that we get back and answer them as quickly as possible. Today, we're going to be talking on workers' compensation. We're going to hear from Lorenda, who specializes in this field, and then we're going to hear from the legislative piece of it from Nicole and from Hannah. And we have about 2 or 3 more webinars that we're going to be hosting. I'm looking at them right now. Our next webinar is going to be next Thursday, June 4th, and that's going to be Jennifer McCusker, who's going to be speaking from an OD perspective, neurology of COVID and how it's affecting employees and how companies can engage those employees from a neurological standpoint, which is fantastic. Then we have 2 to follow after that, a compensation webinar on June 11th, and then on June 25th, OC Tanner will be holding a webinar based on the remote workforce, the new culture within COVID, and their pulse survey. So we're really excited about today's webinar and the future webinars that we've built. We've had absolutely incredible attendance throughout all of these webinars, and we're looking forward to learning a little bit more about what's going on in the world of workers' compensation, because it's the wild, wild west right now with everything that's legislative, with everything that's insurance related. If you blink, there's 10 different changes. So with that, I'm going to turn it over to Hannah and let Hannah launch us on our webinar for today.
Thank you, Andrew, and we're so happy to be back here today with you all, and covering this topic, which again has changes that we're all navigating through. Before we really jump into the substance of today, though, I did want to go ahead and mention that Nicole and I are not workers' compensation attorneys, but we will be, looking at this from an employment law perspective and covering some of those updates, because we do deal with issues related to workers' compensation in our practice, but we just did want to make sure and mention that, that is not our specialty or, our primary practice area. So with that, we are going to cover the executive order, regarding COVID-19 in the workers' compensation and how that impacts employers. We're also going to cover some of the COVID-19 litigation trends to look out for. And workers' compensation is one of those, but there are many other litigation trends that we're seeing. And in fact, our firm has now created a dedicated page for litigation trends, and where they are, all the different COVID-19 related litigation throughout the United States. You can actually go to our website and see which claims have been filed in which states, and it's a very comprehensive, overview. And then we're also going to cover some other updates. There's been some OSHA updates, some Cal-OSHA updates, and so those are also important to cover today. And then Lorenda is going to take us through experience modification ratings. and COVID-19 related claims, and also the temporary reclassification of remote workers. And then we'll also cover some tips to minimize COVID-19 related litigation and claims. And as Andrew mentioned, if you have questions throughout, please do feel free to type them into the Q&A box, and we'll try to address them throughout this time as we're going through the material. And if there's something we don't get to, we'll try to get it at the end, and if not, we'll definitely follow up with you. So with that, I'm going to go ahead and hand it over to Nicole to take us through the first part.
Great, thank you so much, Hannah and Andrew, and everybody listening, thanks for joining us again. So I'm going to be covering the executive order that was signed on May 6th with regard to workers' compensation. And it's been widely reported that Congress, federal Congress, has been debating proposed laws that would immunize employers from potential lawsuits attempting to allege that workers had contracted COVID on the job, whether it's negligence, whether it's a personal injury, whether it's a wrongful death. But in California, while employers certainly have many concerns with regard to COVID-related claims, which we are going to talk about, those specific concerns are less at the forefront, because for the most part, employees who suffer work-related injuries generally can't bring their claims in civil court. They bring those claims through the workers' compensation system. And if they do try and bring those claims in through a civil lawsuit, we assert affirmative defenses or try to otherwise exclude those claims as barred by workers' compensation. And so some of you may be familiar with that, and that is a pretty common process. But this executive order that came down in earlier May, it does anticipate an increase in workers' compensation claims related to coronavirus because of what it does put into play. The executive order is retroactive to March 19th, 2020, and is extended 60 days from the date it was signed, the May 6th date. So it's through July 5th, 2020 currently. And so, if it is going to be extended, we don't know, but this is the current time frame, March 19th through July 5th, 2020. The order does have significant impact, but a question is how it impacts claims that have already been accepted prior to the effective date and claims that are denied. And when the order first came down, of course, there was a lot of open questions, and then the Labor Commissioner issued a set of FAQs. FAQs have now become our best friends. We welcome them, we read them very closely. And the Labor Commissioner's FAQs clarified that a claim that was accepted prior to May 6th, the executive order does not apply to such claims, and they will be administered just like they would any prior claims that had been accepted through the workers' compensation process. However, if a claim was denied prior to that date, the employer has the option to reconsider and to accept based on the terms of the executive order. Or if the employer does not do that, then the employee may file for a hearing with the nearest Department of Workers' Compensation office. And so that has been clarified under the FAQs that were issued. In terms of what the order does, the main driving force is that the order creates a rebuttable presumption. And what is a rebuttable presumption? It's kind of a legal term of art, but it's essentially that the employee, as long as they meet certain criteria, which we'll go over, is presumed to have become ill from COVID-19 at work, so on the job, that it is a work-related illness. But the employer can dispute that conclusion, can refute the claim, can offer up evidence to counteract that claim. The burden, though, is on the employer to prove that, to prove that the exposure did not occur at work. So it's taken as true unless and until the employer can prove otherwise. And COVID being what it is, a very highly communicable disease, easily to transmit and very hard to identify where the exposure took place, that burden of proving that it did not occur in a workplace setting or in the course of work is going to be fairly challenging. So that was a question that came up quite a bit, is how are we going to meet that burden? How are we going to prove that claim? And we'll talk a little bit about that. So that's what a rebuttable presumption is. How can employers overcome the presumption? Well, there are certainly the regular ways that we would go about it. We would gather available information, we would do an investigation, we would take a deposition, we would subpoena records, but we have a shortened time frame to do that now. So under the executive order, employers have 30 days only to put up information to rebut the presumption. In the past, it was 90 days, or not subject to this order, it's 90 days. So now doing all that, setting and taking a deposition, subpoenaing, receiving and reviewing documents, medical records, all within 30 days is also a very high burden and a challenge for employers. But something to consider in terms of how employers can overcome this presumption, we've gotten a lot of guidance from different agencies, and OSHA recently issued a enforcement memo with regard to reporting COVID issues or COVID cases. So there's we're going to mention this a little bit later as well, but there's a revised enforcement guidance that came out May 19th for reporting cases of coronavirus. And in this memo, there's some helpful information, and this is specific to whether or not the case needs to be recorded on an OSHA log. And it does have to be reported if it meets 3 certain criteria, one of them being that it's work-related. And the memo gives the employers some framework to determine whether a COVID case is work-related. And for example, when several cases develop among workers who work closely together, and there's no alternative explanation, if it was contracted shortly after a lengthy close exposure to a particular customer or coworker with a confirmed case, or if the job duties include having frequent close contact with the public in a locality with ongoing transmission. So those would be ways to show that it is work-related. However, it's possible to show that it's not work-related if the individual is the only worker to contract COVID in their vicinity, and their job duties do not include having frequent contact with the general public, regardless of community spread. So taking from that, employers can use that information or use that argument to support a potential defense to a workers' comp claim. Similarly, it's likely not work-related if outside the workplace, the employee closely and frequently associates with somebody who has COVID, is not a coworker, and has exposed the employee during a period in which the individual is likely infectious. So taking a look at that information, that guidance could be helpful with regard to a potential workers' comp claim. So I mentioned the 30-day time frame. It is fairly tight, and you want to make sure that you're acting quickly, gathering the information, and working in conjunction with your adjuster, with your carrier, with your support system to make sure that you are providing all available information. Within that period, until there's a determination made, the employee is eligible for up to $10,000 in medical treatment and may be eligible also for FFCRA, paid leave, and other COVID paid sick leave that might be available to that employee. In terms of the notice requirement, we're going to let Lorenda give her input on whether a DWC-1 form should be provided, but the DWC-1 form is the form that's generally given to employees in the event of a work-related injury. And so that's been a question of, how and when and under what circumstances are we to give employees that form? It also does start the statute of limitations running on a workers' comp claim. So there's a lot to consider in whether and when to provide that information. So on the next
there's a question before I move on to the next slide. There was a question that came through about, does an employee carry liability for, coming to work if they knew they were infected? And I think, we're going to, talk a little bit more about these COVID-19 related litigation trends, but I think definitely, if you look at other, kind of things that you could compare this to would be, in certain states, yes, if somebody, knowingly infects somebody with HIV, there are, civil action and even, criminal action that can be taken against somebody. So I think we're going to see, new kinds of claims related to that and potential liability from an individual that knowingly did that. And I'll cover some of the new claims that we're seeing. Anything you think about, Nicole, there?
No, I agree with you. And if you can prove that that employee had that knowledge, you know, maybe they got a positive test result before they came into the workplace, and withheld that information or came to work regardless, certainly that's going to help refute that it was work-related and deny any potential claim. So yeah, absolutely, that it will be relevant.
One additional thing I'd like to add, we've had a couple questions come up about having access to the deck. We will be sending out a recording afterwards. You'll get one automatically from Zoom, and then LA NHRA will also upload this presentation to our YouTube, and we'll email that out to attendees as well.
Perfect. If anybody needs a link to the executive order or the FAQs, we're happy to provide that as well. We can send that around with the email, possibly. If not, we can send it directly. In terms of who the order covers, so we talked about the rebuttable presumption, we talked about how employers can potentially overcome that, timing and notice requirements, but who exactly is covered by the order? So it's all California employees, and there was debate over whether that should be all employees, whether this should just be essential workers, whether this should just be medical workers, but the California government went broad and encompassed all California employees who work at a job site outside the home, so does not apply to remote workers. If employees are working remotely from their home, this does not apply. The presumption does not apply. It would be the standard workers' compensation analysis. They work outside the home at the direction of the employer. So if the employee is choosing to leave their home for work-related purposes or without authorization, that would be something that the employer would want to raise if that employee brought a workers' compensation claim. Between the relevant dates, March 19th to July 5th, and that the employee tests positive for COVID-19 within 14 days of working at the job site. So all those elements must be met in order to have that rebuttable presumption in play. In terms of the medical certification, the employee has to be diagnosed by a medical doctor and have that diagnosis confirmed by a positive test within 30 days of the date of diagnosis. So it's not just a doctor saying you have all the symptoms, you know, maybe you were around somebody also at work who had been even tested positive or had had symptoms themselves, but there has to be a positive test result within 30 days. And the FAQs do talk about the different types of tests available, the test for the antibodies and then the alternative test as well. In terms of the use of FFCRA leave and other benefits, the executive order does, and the FAQs do clarify that if there is paid sick leave that's related to COVID-19, so if there is FFCRA or even if there's other available, so let's say there's a local paid sick leave with regard to specific use for COVID-19 related reasons, then that must be used before any temporary disability workers' compensation benefits come into play. So that will be exhausted first. If there are any other benefits like underlying existing company policies, PTO, paid sick leave, local, state, then the temporary disability will trigger at the date of disability, and anything that was used or applied has to be restored to the employee. So there's a distinction there, COVID-related leave benefits versus non-COVID related benefits. We mentioned in here serious and willful and Labor Code 132A. So these are two claims that Hannah and I actually handle fairly regularly. So these are outside the workers' compensation system. These are civil claims that are affiliated with workers' compensation claims. A serious and willful claim is where the employee alleges that the illness was caused by serious and willful misconduct, malicious, intentional conduct by the employer that created an unsafe work environment and led to the injury. And then a Labor Code 132A claim is a claim that the employee was discriminated against or wrongfully treated because they asserted a workers' comp claim, filed a claim, raised an injury, threatened to bring a claim, anything protected under the workers' compensation system. And these are fairly common, but they're generally excluded under most workers' comp policies. And so you will oftentimes have to bring in a civil employment attorney to defend those claims. Usually we work in very close contact with the workers' comp, either carrier attorney or the attorney assigned to the claim. But it will require some different type of analysis and different type of work. And for the serious and willful in this type of situation, we can certainly foresee more of those type of claims if the employee can prove or even allege that the employer maybe brought employees back too soon. Maybe they were not in a particular category that was sufficient at this point in time to bring employees back to the workplace, didn't provide proper PPE, didn't enforce social distancing policies. Anything that we've kind of talked about with regard to ensuring that safe and secure workplace, if that can be proven to be done maliciously or intentionally or willful disregard, then that can lead to a potential serious and willful claim that will be tagged on or tied on to a workers' comp claim. And then similarly, if an employee loses their job, is demoted, has a pay reduction, has any sort of adverse action related to or following notice of their injury or notice of their positive test result or their claim, that could lead to a Labor Code 132A claim as well. And then in terms of the compromise and release, we mentioned that because the compromise and release is in the event the claim is litigated. So if it's denied and appealed, or if there's any dispute over the benefits, and that there's a resolution of that dispute, in the workers' compensation system, that's called a compromise and release, a CNR. There's only acronyms in workers' comp, right? So it's a CNR. And generally, that CNR will have a lot of check the boxes for employees to kind of waive a lot of their claims, but they will not be waiving their civil claims. So they won't be waiving any wrongful termination or any harassment, discrimination, or any wage and hour. So what we like to do is, if we're involved, if there's a serious and willful, or if there's a Labor Code 132A, or even not, if we're brought in by our clients, we can either add some consideration or we can carve out some of the consideration to apply to a civil release, a general release, that we would then attach to this settlement. We would have to work in language into the CNR, because the CNR says this is only for the settlement of the workers' comp claim. So we would exclude that. We would include language as appropriate, and then we could get the employer a broader release than just a release of the workers' comp claim. Some workers' comp judges push back on that, so you oftentimes will have to do it outside of their purview. But it is a good way to get a broader sense of closure, particularly if you have a separated employee, and you want to kind of have that peace of mind at the end of the day.
So there was a question that I saw come through as well on this here, asking, what about if the person works from home but was sent out to work to another location where a lot of employees are working? Mm-hmm. And so I think this question raises, the issue of, if you have somebody that's working at maybe a third party work site or, somewhere that you're not in control of, there are a few things to keep in mind. And in fact, the guidance that Nicole mentioned that we'll be covering a little bit further, the OSHA guidance actually has specific guidance on investigating and looking into employers that are joint employers, for staffing agency relationships, and also for third parties. So in investigating where was it contracted from, and all of those things. But also in this part of it is really important to make sure that when you are, having employees going out to a third party, you are ensuring that third party is also in compliance with, local, state, and federal orders, in compliance with CDC guidelines, all of those things. Is there anything else you think to add to that, Nicole?
I mean, that's a very good point. I think, the obligation on the employer to ensure that safe work site, regardless of where the work site is, whether it's the home office, whether it's we have employers that have that are in the construction industry and they have on-site, or they're going to customer locations and they have to make sure the customers are taking precautions and following their protocol and their policies. Absolutely, you're in line in terms of making sure that whatever the environment, your employee is as safe and as protected as possible. But in terms of that specific, the employee working remotely, the FAQs are very clear that the employer's job site is not the home or the residence. So if they're going to a third party, they're going to a customer location, if they're going to the main office, if they're going to a remote office, as long as it's not the home or the residence of the employee, then the presumption may apply as long as all the other conditions are met. So now I think we'll hand it over to Lorenda to talk a little bit on the DWC-1 form, which I think is going to be really helpful information.
For you that are familiar with the work comp claim process, the employer is required to provide a DWC-1 form or employee claim for workers' compensation benefits within 1 business day of your notice or knowledge from any source that the employee was diagnosed with COVID-19 and COVID-19 was contracted at the workplace, or the employee is claiming that is work-related. Now, the source of that knowledge can come from the employee's family member, the employee's physician, an attorney, and also maybe a public health official. But anytime you receive that notification, that DWC-1 form needs to be provided to the employee. COVID-19 related claims should be reported immediately to your workers' compensation insurance carrier. You can dispute the claim at that point, but be prepared to provide evidence to rebut the presumption that the employee did not contract COVID from work. Nicole touched on some of the areas or information you can provide for the carrier, but I wanted to also reiterate, if the employee takes public transportation on a regular basis, or you want to investigate whether the employee has traveled locally or internationally, as well as was the employee a participant in a gathering of 10 or more people where they could be exposed, or anything that may help in rebutting the presumption that the injury occurred at work. And this is where your employer level investigation would take place to determine this information and interview the employee, maybe their co-workers, to determine if there is any evidence to rebut the presumption. As Nicole stated, the insurance company under 5402 usually has 90 days to make a compensability decision. For COVID claim, it's only 30 days from the employer's knowledge, not from the date the insurance company receives the claim. So therefore, you need to report that claim right away to protect that 30 days of discovery.
Great, thank you. And just in regard to the notice, Lorenda, it could be somebody that comes in and just verbally provides notice. Is that right?
Yeah, it could be verbal, it could be in writing, but any form of notice where the employer has to make a decision and investigate further, then a claim form needs to be provided.
So now moving into this COVID-19 litigation trend. So, as we're just trying to navigate through, what restrictions are now, lifting, which ones are still in place, we're already dealing with COVID-19 litigation. So plaintiffs' attorneys already are filing lawsuits. We have now already seen several lawsuits filed on, many of these issues. And, we're expecting many more. So I think it's really, just kind of being aware of what are some of the potential issues that are already being claimed and the ones to look out for, and how can you prevent or at least mitigate the risk in those claims. So one of the areas that you can expect to see is the FFCRA litigation. So we already are seeing that individuals are bringing claims that they were not properly paid for time that they were qualified for FFCRA, paid sick leave. So we're already seeing that, as you would expect. We have already seen WARN litigation. Hooters actually was one of the first, or the first, to get hit with a lawsuit for not following the WARN notification standards. So again, we're probably going to see more WARN litigation, and that has been brought on a class-wide basis. So with employers that are going to continue to lay off employees, it's really important to consider if WARN is triggered and if those thresholds are met. Wage and hour, we're also expecting to continue to see wage and hour litigation. Some of the claims that we're already seeing, come out of failure to pay wages on separation. So as a lot of employers were scrambling to figure out what to do when a lot of these stay-at-home orders were implemented, a lot of employers, had to lay off employees or furlough employees. And in the state of California, if you furlough an employee for more than 2 weeks, essentially, generally, then you've essentially laid them off. And when that happened, a lot of employers didn't pay all wages on separation, meaning they didn't also pay all the vacation. So we're already seeing claims related to that. We're also seeing, potential claims related to temperature taking and the time that employees are going to be spending taking their temperatures, showing up to work, and then being sent home. So reporting time pay issues. We're also seeing a lot of claims that will be related to remote work. So employees that are having to incur expenses at home, not being reimbursed for those expenses, and even just the time and meal requirements not being as strictly followed as employees are working remotely. So those are cases that we're already seeing, but also we plan to see more of. And so this is just one area to remember to really comply. Then wrongful termination, discrimination claims are also really ripe here when we talk about COVID-19. So employees that don't feel comfortable returning, and as you've been part of our talks in the past, we've really talked about this issue, but this is one where if you just lay someone off or terminate their employment because they said they don't feel comfortable coming back, that could potentially give rise to that kind of claim. Also, we're seeing it in regard to PPE, somebody that refuses to wear PPE and then is terminated or not put on the shift. That's another area where someone could bring a claim for wrongful termination. Discrimination, again, being in a protected category, and then being treated differently for that. It's really one to look out for. And again, the EEOC and ADA, there is good guidance on the EEOC's website regarding kind of what to follow in regard to asking for information for related to medical information, and being aware of all of that as well, and whether or not you decide to have someone come into work who might be in a vulnerable category. There's all of those things to consider. And then whistleblower actions, we're going to see probably a rise in whistleblower actions, again, for maybe not complying. So somebody's complaining that we don't have the right safety protocol in place, and we then terminate that person, or that person's part of layoff. They're going to claim that they had complained and then they were terminated, and that can give rise to whistleblower claim. Workplace safety compliance issues are huge, and that's kind of, I will cover that kind of as I discuss these other unique claims, but this is going to be one of the big ones, and why it's really important too, not only that it's required, but having, you know, a workplace safety plan in place really helps, you know, defend against such a claim. And then also, you know, OSHA is going to be ramping up their, you know, investigations and citations. And something we hadn't seen in the past was, you know, employees and plaintiffs' attorneys really going after, you know, OSHA and complaints and, you know, following through on those, because they really didn't have any, you know, basis to do so. And plaintiffs' attorneys really didn't, you know, they weren't that interested in OSHA. But what we're seeing now is we're seeing a lot of plaintiffs' attorneys interested in pursuing OSHA actions. If OSHA then issues a citation, then what we are seeing is plaintiffs' attorneys wanting to pursue an action based on that citation. And in some states, actually, the citation can be a basis for a claim. So that's one of the reasons as well to have, you know, good workplace safety compliance. And then, you know, as we're talking about today, workers' compensation claims, you know, the change that has occurred here in California with regard to the presumption, wrongful death claims out of employees that may, you know, have actually contracted it and then actually die. And then we're also seeing claims related to wrongful death and negligence claims coming from third parties, you know, customers. And so those are also to look out for, not just our employees now, but, you know, other claims coming outside of that. And those types of claims are not covered by workers' compensation. So it's really important to take a look at, you know, your insurance policy, what is covered, what is there, really sitting with the broker and making sure, you know, thinking through all these potential litigation you know, avenues, and would you be covered in the event someone were to bring such a claim against your business. And then workplace privacy, taking temperatures, as we discussed last time, really kind of the issues that go, you know, hand in hand with temperature taking and collecting the information and maintaining that medical information. And, you know, all of that. So with regard to unique claims, as I was mentioning, really that OSHA, you know, kind of pursuit and then into an individual action is one we're seeing. But another one is we're seeing claims that we really didn't see in this context before, which are claims for, you know, fraudulent misrepresentation or intentional misrepresentation. And these kinds of claims are getting originated and being alleged on the basis that, you know, you fraudulently misrepresented that the workplace was safe. You knew you hadn't followed the state and local guidelines and the federal guidelines. You know, those are how these kinds of claims are being articulated. So we're not just seeing, you know, our regular wrongful termination, discrimination. Now we're seeing some, you know, really serious claims with regard to, you know, what they're alleging an employer did. And so again, that goes back to having policies and showing the steps you took to ensure the workplace was safe, you know, could help defend against claims like that, that you intentionally misrepresented or fraudulently misrepresented, you know, the safety and workplace. So those are really kind of what you can see on the horizon, some of which we're already seeing. Like I said, if you're interested in this area, we also have a very comprehensive, you know, map of the United States covering this litigation. And then talking about updates. So Nicole did mention some of these updates briefly, and so I would like to go into them a little bit further. So with regard to Cal-OSHA, the IIPP guidelines. So as of May 14th, Cal-OSHA did update their guidance. So they provided interim guidance, and they have made clear that, you know, the IIPP does most likely need to be updated to address COVID-19. And that's something I think we did mention last time. We've prepared already, you know, we have those documents prepared, whether or not it's an addendum or just the full IIPP, including the COVID-19 concerns. We have that included in there. So this is, you know, California employers are required to establish the IIPP. And the Cal-OSHA website actually also has really helpful FAQs. As Nicole said, we all love FAQs now, but they're also very helpful. So if you go there, there's a lot of good information there, and just really, you know, it goes through kind of the requirements for an employer, and some of which are, you know, providing, you know, kind of the guidance as to, you know, the training and different, you know, sanitation and things to be followed. So that's helpful. And so with regard to the OSHA revised enforcement guidance for recording cases of COVID-19, Nicole also touched on this. So as of May 19th, so that was last week, OSHA published updated guidance for recording COVID-19 cases. So it was a little unclear before this whether or not did we have to report these cases, what should we be doing with them, do we have to put them in the log, what are we supposed to be doing? So this is helpful to some extent, but again, it's hard to determine what is work related. And so, and Nicole touched on this, and even Lorenda did as well. So this guidance that was published really tells us in which situations do we need to record the illness. So what is important here is that, you know, you really have to conduct an investigation essentially into the case. So if the case is confirmed, you still need to ask questions. So I'm going to go through here kind of the requirements because I think it's helpful. So in determining whether an employer has complied with the obligation to figure out if it was work related, basically they're going to look at these three things. So the reasonableness of the employer's investigation. So they do give some leeway for smaller employers, but what they provide as guidance is that they ask and they state that it's sufficient in most circumstances for the employer to ask the employee how he believes he contracted the COVID-19 illness while respecting employee privacy. So that's one of the issues that I think is difficult. So we're supposed to be asking about how the employee contracted it, but make sure you respect the employee's privacy. Again, some of these things are difficult to navigate through. And then 3, review the employee's work environment for potential exposure. And then the second main point is the evidence that's available. And again, Nicole did touch on some of this, right? So do we have any knowledge that, you know, there were a lot of other employees that were sick at work that did actually have COVID-19? So we need to look at that. And is there evidence that COVID-19 illness was contracted at work? So they should look at if there were cases developed, that if an employee COVID-19 illness is likely work-related if it was contracted shortly after lengthy close exposure to a particular customer or coworker who has a confirmed case. An employee's COVID-19 illness is likely work-related if his job duties have frequent close exposure to the general public in a locality with ongoing community transmission. However, if there is no way, and it goes on to list others, but if there's no way for the employer, even after doing this inquiry, to determine if it was work-related, then the employer does not necessarily have to report this in the OSHA log. So otherwise, though, this should be reported. And then also, it's just a reminder that also COVID-19 cases, even if it's not a confirmed case, but there is a hospitalization or the other requirements that would have otherwise triggered the COVID reporting, or I'm sorry, the OSHA reporting, then the OSHA reporting still needs to be conducted and needs to be done so in the appropriate amount of time, which is within 8 hours. So this, you know, this provides us with help. This is the same in California. Cal-OSHA has the same guidance that's in line with this regarding the log. And like I said, the FAQs help provide some further information on that. And then I don't know if there's anything else you wanted to add, Nicole.
Yeah, I'm just going to add one more point, that some of the local orders, some of the local county and city orders have their own independent reporting requirements. And so making sure that you're very familiar with the text of the local orders for that purpose. So some of them, it's regardless of whether it's work related, just a confirmed case in the workplace or a confirmed employee case must be reported as noted in the order. So, so if anybody has an employee with a reported case, make sure you're looking at both the OSHA requirements and the local orders that might apply in terms of reporting.
So now moving on, and we're going to hand it over to Lorenda to talk a little bit about experience modification.
Thank you, Hannah. The experience modification is calculated using two primary data components. That would be claims, also referred to as losses, and payroll. There is no doubt that the impact of COVID-19 will significantly impact this data, potentially resulting in increases in future claim costs and insurance costs. The Workers' Compensation Insurance Rating Bureau intends to mitigate this exposure by proposing amendments to the current rules in order to basically relieve the employer of additional expenses. On April 20th, 2020, after an executive review by the Workers' Compensation Insurance Rating Bureau, they issued a special regulatory filing to the California Insurance Commissioner, which is Ricardo Lara. This filing offered proposals to address COVID-19, specifically amendments to two manuals specifically geared to the experience modification. The first policy would be the Workers' Compensation Uniform Statistical Reporting Plan. These are the policies used by the carrier to submit data to the Bureau for consideration and analysis for the experience modification. Also, the California Workers' Compensation Experience Rating Plan, which dictates the classification of claims, how they are reported, and used to calculate the actual experience modification. Now, please note that while the Workers' Compensation Insurance Rating Bureau has proposed these regulatory changes to the Insurance Commissioner, they have not yet been approved as of May 27, 2020. However, in an effort to ensure that employers can apply these regulatory changes upon approval, it is recommended that you prepare the necessary data and supporting documents. Next slide. Under the current rules for calculating the experience modification, the experience rating includes claims, the current amount paid, and future costs of all compensable claims for work-related injuries and illnesses. When using these claims to calculate the experience modification, there is no consideration given whether it's the employer's fault or the employee's fault. They're just considered compensable claims as submitted for the calculation. In consideration of these changes, the Workers' Compensation Insurance Rating Bureau looked at the following. The COVID-19 doesn't just affect the state. It's a global pandemic whose consequences will be lasting and affect businesses and individuals for years and maybe decades. An employer should not be faulted if an employee contracts COVID-19 in the course of their employment or arising from an employment. The experience modification is calculated based on the data from three past years of predictive data to determine future costs of insurance and claims. Now, no one could predict that COVID-19 will have a significant impact on the world's economy and the population. So that's a consideration used to determine these regulatory changes. So they have concluded that any claim resulting from COVID-19 will be excluded from the experience modification calculation. Next slide. In determining which claims should be included, these claims have to arise directly from the diagnosis of COVID-19 where the illness arose out of employment or the course of employment. In order to determine these claims for exclusions, all the following must apply. An accident or illness date which occurred on or after December 1st, 2019. Now, this was superseded by the executive order, so we don't know at this point if this date will still be valid or the date of the stay-at-home regulation. Now, the claims are reported on the unit statistical report that is due August 1st, 2020. So the earliest date would be a policy incepting 12/1/18 to 12/1/19. For a December 1st calculation of the experience mod, the loss evaluation would be June 30th, 2020. Therefore, the report is required to be filed with the Workers' Compensation Insurance Rating Bureau 60 days after that date, or August 1st. Additionally, the carrier must classify that claim with a catastrophe coding of 12. In addition, they will use a cause of injury of 83, which would be pandemic, and the nature of the claim as COVID-19. Next slide. As I said, payroll is a component in calculating the experience modification. So employers are wondering, why should they incur the cost of a higher classified employee when the employee is reassigned to work at home? To adjust to that, they're proposing that payroll be reassigned. As a result of Governor Newsom's stay-at-home order, many employees who are now performing, who have non-clerical jobs have transitions to working at home. As a result, they are no longer performing their usual and customary job duties, and so the employer should not have to classify those employees at a higher classification. To alleviate the inequity of the proposal to be made, employees who are working at home due to the stay-at-home order have been reassigned to classification 8810 or clerical classification. In determining the current rule for determining the basis of payroll, the division of payroll between clerical and any other classification is only permitted if it's a single permanent job reassignment during a policy period. The proposal, as mentioned before, is to assign clerical classification 8810 to employees if the employee's duty meets the clerical office definition, and also the employee's payroll for the balance of the policy period is not assigned to a standard classification that specifically includes clerical office employees, and also the employer should maintain appropriate records. Next slide. The proposed rule, and this is effective with the stay-at-home order and concludes after the order is lifted. So employees whose payroll does not fall on a classification of clerical employees, which is 8810, will be reassigned to this classification. Now, there are some classifications such as law firms and insurance companies, auditing and consulting firms whose employees, whose classification does include clerical employees, but they're not specifically labeled as 8810 employees. Those employees will be reassigned to classification of 8810. Of course, if you have employees who are already classified as 8810, their classification will remain the same. If you have employees who have a classification which is lower than the clerical 8810, and the rate is less than 100, the rate is less than clerical per $100 of payroll, they will retain that lower classification throughout the designated period. Now, if you have an employee who is an outside salesperson, that is in violation of the stay-at-home order, and they will automatically be reassigned to 8810. Even if that employee is conducting business and telecommuting, they still will be classified as 8810. Next slide. For the basis of payroll in calculating the experience modification, non-work activities, including sick and family leave, are included in that basis, and that's for auditing purposes. But due to the stay-at-home order, there are payments being made to employees who are not actively working for the employer, but still receiving wages. So the employee is performing no duties of any kind for the employer. Those amounts are excluded, do not exceed the employee's regular rate of pay, and the employer must provide appropriate records. Say, for instance, you have an employee who is, say for instance, you're a union and you have a wage continuation statute in your bargaining agreement. You will continue to pay those employees, but that amount of payroll will be excluded from the base of payroll used to calculate the experience modification. Now, some employers may classify someone, they may pay the employee, they may, I'm sorry, I think we're having technical difficulties. Can you go back to the prior slide? Okay. Some employers may increase the wages they normally pay the employee in order to avoid reporting that payroll to the Workers' Compensation Rating Bureau. That's why they established the criteria that the amount being paid to the employee cannot exceed their regular rate of pay. Next slide.
So as we go, and thank you, Lorenda. So I just wanted to ask a couple questions just, in that area. So with regard to the clerical classification, that's because that ends up saving money if they're reclassified as clerical, as opposed to what other classification they would have otherwise had, correct? Unless they already have a lower classification.
Right, because right now the rate for clerical employees is 28 cents per $100 of payroll. So say for instance, you have someone who has a rate of pay of $1.50 per $100 of payroll. You can use a lower classification in order to report their payroll for experience modification purposes.
Right. And we're still waiting for that to be approved, correct? All of this is a proposal we're waiting for, is that right?
Right. As I said, as of yesterday, as of the 27th, I checked the Department of Insurance website, and there still has been no approval of the proposals.
Thank you. So, just kind of looking at, all of what we've talked about today and, really what can we do to help mitigate, liability? What can we do to minimize our liability for, COVID-19 related claims? A big one is really looking and following the local, state, and federal orders. Someone brings a claim, you could point to the fact that you're following the guidance that's been provided. Also, following the guidance of CDC and OSHA is really critical. And there's a really good question. We're going to address it actually on this point exactly. I think it's really important to follow this guidance because that's what we have. And that's what, you know, if you're following this guidance, then you're doing what you can to ensure that you have a safe workplace. Having a plan in place that's in line with the local, state, federal, and all this other guidance, again, this helps protect you. Also helps, you know, following all of the experts out there trying to tell us and give us direction as to what they believe will help minimize exposure when it comes to COVID-19. So that's, you know, part of this here. Training employees and also managers is critical because it's going to help everyone follow this protocol that's in place, and maintaining, you know, a safe workplace and having all these documents won't work unless everybody kind of really understands how to follow through on that and how to report, you know, if they're not feeling well, and what to do if somebody comes on site and doesn't follow directions. You know, I think Nicole gave a good example of, you know, a situation we've already heard where the receptionist was really well trained and, you know, was able to tell the OSHA inspector that, you know, he wasn't wearing a mask and he wasn't allowed to come in unless he had a mask. So that's why training is really critical. Third parties, you know, making sure third parties, you are ensuring that they're in compliance as well through documentation, but also, you know, third parties that come on site, you know, doing a screening process for them, ensuring they're not sick individuals reporting to your work site that could potentially infect other employees. Also having proper notices up. So, you know, one of the documentation forms that we're really encouraging is really having employees signing off on the workplace safety plan. Also PPE that is provided and having, you know, training on it, and also acknowledging, you know, how to follow and do all of those, you know, all of the protocol with regard to the PPE. And also with regard to any screening that's conducted. And whatever your workplace is choosing to do, making sure that you have the right protocol in place and making sure you have the right, you know, acknowledgement form from employees as well. And then just remembering, you know, even though we're dealing with all this COVID-19 stuff, you know, our regular obligations haven't gone away. So with regard to wage and hour, you know, as we mentioned earlier, just tracking time and, you know, doing all of the things we would be vigilant in doing if this situation wasn't in front of us, then those are things we need to remember to continue to do. So I think, you know, I'd like to look at that question and share it with everyone and then, you know, address it. So the question was, whether or not, so studies have shown that asymptomatic individuals can infect others, especially 24 to 48 hours before they develop any symptoms. And about 44% of cases result from infection by asymptomatic individuals. How does that affect employers' liability if they follow OSHA, CDC, California county guidance and allow employees to work if they might have been exposed to the virus but are asymptomatic? And thank you for the compliment. So I think this is a good question, but again, it really does go to this, is that, you know, right, we're not necessarily saying you know, you don't have a crystal ball, we don't have a crystal ball, and I don't think anyone does, as to whether or not we're going to be able to absolutely keep away everybody that may potentially have COVID-19. But if you're doing everything you can, you're going to be in such a better position to defend against anybody who were to claim that, you know, you allowed somebody who was sick to come on site. So that's kind of where this really is important to follow the guidance.
And I'll add there that as part of the documentation that we're putting the finishing touches on, are checklists that gather information about where an employee has been in the past 14 days, you know, as they're returning to work, as they're coming back into the workplace, have they been exposed to anybody that's experienced symptoms within the past 14 days? Have they been exposed to anybody that's tested positive within the past 14 days? Have they left the state? Have they left the country? Other conduct, has anybody visited them from outside the state? So this is all information that you can gather to make an educated decision about how you're going to be treating that employee. And then again, the CDC has different guidance for essential workers versus non-essential workers that may have been exposed to COVID-19. So essential workers can continue working under certain criteria versus non-essential workers, there's different recommendations. So it is somewhat fact specific, but as Hannah mentioned, just having as much documentation, protocol, policy in place so that you have as strong a defense as possible. The training, the notices, the postings, the reminders, the reinforcement, the testing or the symptom check, the gathering of information, the reminding anybody who comes into the workplace, the messaging, everything is going to be, it's going to be a holistic approach that's going to be helpful as we move forward and as we're unfortunately probably having to defend claims that are going to come up.
I wanted to add that under the sick leave policy, if the employee is receiving government-related sick leave, that is going to be excluded from the experience mod calculation as well. And then someone had a question asking for clarification of outside sales. They will be classified as 8810 if they are working from home or working remotely.
Thanks, Lorenda. There's a few other questions, Nicole and Hannah, that are in the they're in the chat box. Actually, I don't think they're in the Q&A box. I'm not sure if you're seeing them.
Okay.
Yeah, look in the chat box.
Yeah, so I see one about, is it okay to give employees a thermometer to measure their own temperature, or does someone at the company have to monitor?
Right.
Certainly employees can monitor and report their own temperatures. It's similar in terms of wanting to provide the proper CCPA notices and maintaining, if you're going to be keeping a record of that information, it should be treated as confidential medical information. If the time that employee is spending taking their own temperature should be compensable time, all these little wage and hour issues. If you're providing them the thermometer, there's not going to be a reimbursement issue, but if they're using a personal thermometer, we're concerned that that could raise an issue. But certainly self-reporting is something that certain companies are doing, particularly if they have workers who are working remotely and then going out to different work sites or going to customer locations. They may not be coming to a single location on a regular basis. And so there does have to be a way to monitor and to gather this information. And so self-reporting is one way to do it. And then in terms of frequency, you know, is this done on a regular basis, once a day, multiple times a day? Most companies are doing this as employees are entering the workplace, before they actually enter the workplace usually. Again, compensable time, they're under the employer's control. But certainly as part of the training and part of the policy is communicating to employees that if you experience symptoms at any point during the workday, you need to immediately notify management and leave the workplace, because there needs to be, that needs to be addressed accordingly.
There's a question says, do we need to reclassify employees who are receiving PPP but not actually performing work? Is that personal protection?
Oh no, the paycheck.
Yeah, it's the loan.
Pardon me?
It's the loan, the stimulus package that was passed in
okay. Okay. No, they're not going to be reclassified because they're not performing any work. So that if that payroll is that going to be excluded from the basis of payroll. Employees who are actually working, who are working from home, they are the ones who will be reclassified to the clerical 8810 classification.
Okay. I see another question about, can a third party or client request that our employee wear a face mask? And certainly, you know, there's the orders, several of the orders do require that individuals wear face masks when they're interacting with customers or with coworkers. Los Angeles has that in place, a lot of the other local orders. So that would be something that a lot of employers will want to just have as a practice. And then if you don't have that in place for some reason, maybe as an accommodation or for some other reason, and the third party or the client makes that request, that should be respected and complied with, particularly if it is required. And if the employee objects or pushes back, that would be a trigger for a dialogue as to the reasons and whether there could be an accommodation that could be provided. For example, a face shield, a mask of a different material, you know, finding out what the basis is for it. Anything else, Hannah?
So another question came in, can a third party request an employee to be tested prior to entering the home of a client? So with regard to testing, yeah, so there's been guidance with regard to testing, and it is specific, and this sounds to be specific. So with regard to, you know, going in home and industry specific. So again, if you want, we could actually specifically talk about that separately. But just as a general rule, the EEOC has provided guidance that testing is allowed, and employers can require testing. That is the guidance they have provided. And on this particular issue, you know, again, I can speak to you further if you'd like.
There's a new question. Do you see it?
Yeah, in the Q&A box, it says, can we require employees to sign a risk waiver if an employee that was tested positive got family members infected? It's interesting.
Employees to sign a risk waiver if an employee that was tested positive.
Okay. So I think, and again, I'm not sure what you're necessarily referring to with regard to a risk waiver, but, you know, there's a lot of talk about waivers, you know, that has come up, you know, during this time, and whether or not, you know, you can have employees sign a waiver and, you know, whatever it may be. So one thing is a lot of times, you know, waivers are, even if you have somebody sign a waiver, it's not enforceable. So whether or not you actually have somebody just sign a waiver, you know, there's a lot to consider with regard to waivers, whether or not, you know, it's even worth having them do that, right? Because they could come back and claim, you know, they were forced into signing the waiver, and you could lead to bad publicity for certain, you know, businesses. And we've already seen that come out for certain businesses, and it causes, you know, bad publicity if you're having someone sign a waiver that, you know, they're waiving something they couldn't have waived anyways, and it's in a piece of paper. So I think that's kind of what to consider with waivers. Acknowledgements are a little different because it's acknowledging, you know, maybe some fact that may take place, and so that's why there is a distinction between a waiver and an acknowledgement.
Yeah, I'll add that, like Hannah mentioned, there's certain claims that just as a matter of law can't be waived, like a workers' comp claim. So, you know, a lot of waivers are just going to be unenforceable, but we have prepared for certain clients in kind of high risk, high potential exposure industries, like the medical industry, or even supporting the medical industry, acknowledgements that you understand you're coming into a work environment where the risk of exposure may be greater. We're taking every precaution and following every guidance. However, you're signing to acknowledge that this may be a higher risk environment.
There's a additional question, and it comes from Vanessa. As far as an employee not wearing PPE, what can you do as an employee or an employer? And then she adds on, especially if other employees feel uncomfortable about other people not wearing PPE, what is the best way to mediate this behavior?
Right. So, so certainly, if you know, if the PPE is required, then you want to have it mandatory by the company, particularly in areas where the employee is interacting with customers or coworkers or coming into close contact with anybody. Then it's a requirement. Now, if the employee objects, that would be the prompt that it's time to engage in that dialogue with the employee to find out the reasons why they're pushing back. Is it based on a disability? Is it based on religious reasons? Is it based on political reasons, personal reasons? And then what potential accommodation can be provided, or what other types of options might be available? We've gotten guidance from different agencies about providing different kinds of PPE. So for example, if somebody has an allergy to latex, they can request different kinds of PPE. or if somebody has some sort of health condition that a face covering is, a mask is not appropriate, then maybe a different kind of face covering might be appropriate. So these are things to consider before having a blanket rule that if the employee refuses, there will be discipline or termination. And that's one thing to kind of just point out generally in terms of mitigating or minimizing that potential risk of litigation or exposure, is to avoid just jumping to any sort of one strike and you're out rule, and kind of being very consistent in applying these rules, just as you would pre-COVID. You want to be taking a consistent approach across the board. You want to be looking to see if any of these policies might have a disparate impact on any particular group. And you want to be looking at each individually to see if there's any sort of accommodation, if there's any sort of reasonable basis for the opposition or objection or pushback. And I was on the phone with a client yesterday, and this client literally had one of everything. Every potential check the box they had. They had the employee who was scared to come to work. They had the employee who refused to wear PPE. They had the pregnant employee. They had the elderly employee. They had all of the above. And so we had to go through each one and analyze. And it really is, it's fact specific. And we really are, moving carefully because this is a moving target.
There's just one other question, and I think you may have already addressed this, but can employees self-take temperatures? I just thought I'd mention it one last time. I do think you already addressed it.
Yeah, so I think, I think there was a related question earlier kind of, about taking temperatures at home. Yes, it's just to watch out for, the issues that arise when someone's taking their temperature at home with regard to using their own equipment, using the time spent taking the temperature, how are they reporting that temperature, all of those considerations when you have an employee recording their temperature at home.
And a related question of whether you have to log those temperatures. You don't have to necessarily log and keep a log. If you do, it's treated as confidential medical information. Regardless, you should notify employees and of the requirements under the California Consumer Privacy Act. And if you are, again, be consistent. So if you're recording for a certain employee, you do so for all employees or a certain group of employees, even, have a legitimate reason if you're doing so for different reasons.
One additional question popped up. Do you have a sample COVID-19 symptom employee screening questionnaire that's compliant with CCPA? If so, please email. Email to him specifically.
Okay. So on our website, fisherphillips.com, www.fisherphillips.com, we do have a CCPA notice to employees that's California specific. So if there's any reason why you cannot find it on there, please email me or Hannah. We'll help you locate that. And as we mentioned, we're putting together, we're putting the finishing touches on packets, return to work packets, and different policies that should be included as addendums to handbooks that should be finalized in the next couple of days. And if anybody wants more information about that, you're welcome to reach out to either of us as well.
Yeah.
Well, I know I've been blowing up Nicole and Hannah almost daily regarding the questions that are coming in from my clients in my network, and they've been fantastic at responding. So definitely feel free to reach out to them, and if they do, then they will. Lorenda, do you have any last minute thoughts before we bring this to a close?
No, I don't. I wanted to let our participants know that we will be monitoring the situation with the insurance commissioner to determine if those regulatory changes are going to be approved, and we'll notify our clients accordingly.
Right.
And we'll also share that with Fisher Phillips too, so they can notify their clients as well.
Yeah, it's been a great partnership with Fisher Phillips within NHRA and with Bolton as well. So we are at about an hour 20, and that was a lot of information in a short period of time. You will receive an automatic recording of this presentation. However, I will also forward the presentation to all those who attended and registered once we have it loaded onto the LA NHRA YouTube site. When I do that, I'll include Nicole and Hannah and Lorenda on that email. And if you have additional questions, then you can just respond to that email, and we'd be more than happy to answer whatever questions you might have. We're going to take a little break from Fisher Phillips for about a week or two. Our next webinar will be next Thursday, June 4th, with Jennifer McCusker, the former Chief Talent Officer at Blizzard, who is now speaking on the neurology of your employees during the COVID crisis. So please join us on June 4th. Thank you for joining us today. Thank you to Hannah, to Nicole, to Lorenda for joining us and providing all of this information. I know it's extremely valuable. So thank you, everybody. Please be safe, and we'll see you next Thursday.
Thank you for having us. Thanks.
Thank you.
Bye.
Take care, everybody.